All right, I will call this hearing of the Senate Judiciary Committee to order. Will the Secretary please take the roll?
Senator Flores?
Present.
Senator Orenthal? Senator Lang? Senator Wynn? Senator Hansen? Senator Krasner? Senator Ellison? Chair Scheibel?
I am here. It looks like we do not have a quorum this afternoon, so I'm going to request this begin in a subcommittee of the Judiciary, consisting of Senators Krasner, Wynn, Flores, and Scheibel. If we do have some more members join us today, I would ask that we move into a general meeting of the Senate Judiciary. Otherwise, those senators who are not present, let me start with Senator Ellison should be marked absent excused. Senators Orenthal, Lang, and Hansen should be marked present when and if they arrive. Otherwise, they can be marked absent excused. I know that everybody is working around their schedules to present bills in various committees and attend to other obligations. And I think we just made our quorum, if I count correctly. All right, so you can disregard what I just said. We're going to start out in this committee. And Senator Ellison is still absent excused. Senators Lang and Orenthal are still going to be marked present when they arrive. Otherwise, they will be excused. They are both presenting bills in other committees right now. And this afternoon, we only have one bill on our agenda. That is SB 141. There is also a conceptual amendment accompanying SB 141, which is available on Nellis and is also on every member's desk. As it is my bill, I will be turning the gavel over to my Vice Chair, Senator Flores.
And at this time, we'll open up the hearing on Senate Bill 141. Madam Chair, whenever you're ready.
Thank you so much, Vice Chair Flores. For the record, my name is Melanie Scheibel. I am the State Senator for District 9, and I am pleased to be here today to present to you SB 141, along with the conceptual amendment to SB 141. Overall, the purpose of SB 141 is to require that every detention center develop a policy for people in their custody who are gender nonconforming, gender non-binary, or transgender. So essentially, we're saying that every facility has to have something in writing that indicates their policies and procedures relating to attending to the needs of this unique population. I've been working closely with the Sheriffs and Chiefs Association, along with the administrators of all of the various different county and city jails and detention centers in order to develop language that is acceptable to all of these parties. And I think today you will hear law enforcement testify in support of this bill because we all share a common goal of treating anybody who is brought into custody with dignity and respect. When somebody is incarcerated in a county detention center or a local jail, they are generally awaiting trial, although some of them have been sentenced on misdemeanor convictions, so they would be serving sentences of 6 months or less. Regardless of why they are incarcerated, it is everybody's goal to ensure that people who are incarcerated are treated with equality, to ensure that they're treated with respect, to ensure that not only do we uphold these values, but we actually put them in writing. So the purpose of SB 141 is to ensure that today and into the future, we set forth standards that have some kind of it's not just an attainable goal, not just a reachable goal, but something we can point to, a policy on paper, so that we don't end up litigating on the back end potential abuses, potential violations, potential mistreatment of people in custody. We address it on the front end so that everybody knows what's expected of them, so that every facility, every corrections officer, every staff person within a detention center knows what's expected of them and knows how they are supposed to respond when they encounter somebody who is gender nonconforming, gender non-binary, or transgender. I'll just walk through the conceptual amendment very briefly, and then I will pass it over to my co-presenter, Ms. Munger from Silver State Equality. So if you're looking at the conceptual amendment, what I've done in section 1 is to remove the vague subsection A, which included a laundry list of ways that the detention center had to meet the needs of people who are gender nonconforming, and instead created a list of what subsections need to be contained within any policy. I developed this list utilizing the existing policies in each of the 17 counties, as well as the policies I was able to obtain from city jails, which included the Henderson City Detention Center and the North Las Vegas Detention Center. So the requirements in the conceptual amendment largely mirror what already exists in policy for those different locations. So the first one is to ensure, if we go to, I'll just go through it. Subsection A is just utilizing respectful language. Subsection B is a non-discrimination clause. And then subsection C refers to housing. What subsection C says is that the person's preference has to be taken into account when assigning them to a housing unit. It doesn't say that they have to be housed according to their gender preference. They don't have to be housed according to their gender identity. It says that their preference will be taken into consideration. And the purpose of that is to allow different facilities to define the other factors that they want to consider. Those absolutely should include the health and safety of all incarcerated people, as well as staff, volunteers, contractors. And what subsection C says is that the person's preference also has to be one of those factors. Subsection D refers to search protocols, and I think that I'm still working on the language for this part with some of the law enforcement agencies who already have policies in place that do not allow any officer who is, working in the general population, who is, supervising a certain day use area or in charge of a certain cell block, doesn't allow them to require an unclothed search for the sole purpose of observing somebody's genitalia. There are other processes and procedures that can be implemented by the jail or detention center to determine somebody's physical sex characteristics in order to properly meet the other needs of the policies, including that housing policy. The other section of subsection D about searches indicates that, again, the person's preference in who conducts a search must be one of the factors that's considered when assigning officers to conduct a personal search of a person who's incarcerated. Subsection E is lifted directly from a number of policies that are already in existence for these detention centers, indicating that medical personnel must follow their standards of care. It's pretty straightforward. Every medical provider has their own standards of care. Those need to be met for people who are trans, non-binary, or gender non-conforming, same as they would be for anybody else who is incarcerated. Moving to subsection F, this is the purpose of subsection F is to ensure that regardless of where somebody is housed, they still have access to the appropriate clothing and hygiene items that they might want, need, or desire. The subsection F is not intended to make it a blanket policy that anybody's allowed to request anything that they want, but it's meant to address a couple of main issues. One of them being that if somebody is housed in the housing assignment that is not consistent with their preference, so for example, let's say that you have a trans woman who wants to be housed in the women's unit, but the jail, for whatever reason, decides that they cannot house them in the women's unit because it would be unsafe, because it doesn't meet their security protocol, and they house a trans woman in the men's section of the jail. That trans woman may still want access to shampoo and conditioner that isn't generally available in the men's section of the detention facility. And I did confirm that they actually do provide different hygiene items, different shampoo and conditioner in the women's section and the men's section. And so even though that person might not get to be with their expressed gender population, they should still be able to access certain hygiene items or undergarments depending on their physical characteristics that might necessitate them. Another example of this would be where we are housing trans men in a men's prison, and they may still be menstruating, so they should still have access to period products, even though they're in a men's facility, or maybe they're in some kind of independent section. Maybe they're housed by themselves, maybe they're housed in some kind of transitional area where they don't normally have access to period products. Anybody who's menstruating should have access to them. Subsection G also ensures that every policy addresses both adults and juveniles who are incarcerated, because we do have a number of locations where both adults and youthful offenders are housed in the same detention centers. And finally, subsection H ensures that there is a grievance process. You'll notice I've indicated in all of these subsections that the policy has to either include or incorporate by reference another policy. So for example, in subsection H, most jails and detention centers already have some kind of grievance process. It is generally outlined for all of the myriad policies that apply to the jail. And so the purpose of subsection H is to say, if you have a process for an incarcerated person who is, I don't want to say complaining, but whose issue is that they're not receiving, timely medication, there is a process for them to file a complaint, to file a grievance. It should be the same process if their issue is that this new policy is being violated. They're not being provided with, their preference wasn't taken into account before they were searched, or they're not being provided with hygiene items that they should be able to receive. Finally, we added subsection 3 to the bill to ensure that nobody is confused about the requirements placed on governments and local jurisdictions. The purpose here is not to require anybody to build new facilities, hire new staff, develop new programming. It's none of that. It is within their current structures, within the current facilities, the staff they already have, the programs they already do. They just need to write a new policy to ensure that today and going into the future, anybody who comes into their custody who is transgender, non-binary, or gender non-conforming has this, this specific set of policies that protects them and sets forth the requirements for their treatment and care while they are in custody. And with that, I would like to turn it over to my partner here to give a little bit more context for the impetus of this bill.
Hello, good afternoon, Vice Chair Flores and committee members. My name is Jessica Munger, Jessica Munger. I'm the program manager for Silver State Equality, Nevada's statewide LGBTQ+ civil rights organization. Trans and gender diverse individuals face unique challenges and threats when they interact with the carceral system, and SB 141 acts as both a step in the direction of proper treatment of Nevadans who are in jail, as well as helpful guidance and protections for corrections staff. Although research on trans and gender diverse incarcerated individuals is relatively scant, what exists, including large-scale surveys from the U.S. Department of Justice, the Vera Institute, overwhelmingly demonstrates that transgender people are especially at risk for contact with the criminal legal system for a variety of reasons, and once in detention are disproportionately elevated risk for harassment and violence. In the absence of policies like SB 141 and the rollback of policies at the federal level through recent executive orders that have provided policy guidance to jurisdictions by way of the Prison Rape Elimination Act, discretionary decisions about housing assignment protocols, standards for custody, care, security, and medical treatment frequently disregard safety considerations, and this is often due to a lack of information, inadequate resources, inadequate training, and oversight. Some examples of the unique challenges of trans and gender diverse individuals in jail include unsafe housing assignments. As proposed in SB 141, having a standardized policy which designates which factors are considered when assigning the housing of an incarcerated person is key to success and consistency of care. Ideal and effective policies are evaluated on a case-by-case basis in accordance with standardized and consistent factors for consideration. Inappropriate housing assignments expose incarcerated people to heightened risk of violence, sexual assault, and harassment from both staff and other incarcerated individuals. Violence against trans and gender nonconforming people tends to be worse in places that are separated by sex, such as county jails, immigration facilities, and prisons. Another is barriers to medical and mental health care. Transgender and gender diverse individuals face significant obstacles in accessing their medically necessary life-saving medication, medical care, and mental health services. Missing medication and disrupting continuity of medical care contributes to severe physical and psychological distress, often exacerbating existing trauma. So policies for ensuring continuity of care and mechanisms to prevent the denial of medically necessary treatment keep individuals out of crisis. And this makes the carceral environment safer for everyone and allows avoiding unnecessary escalation in these spaces. And on the topic of medical and mental health care, I'll read the position statement from the National Commission on Correctional Health Care. Quote, correctional leaders and healthcare and custody staff have a responsibility to ensure the physical and mental health and well-being of people in their custody. Therefore, health staff should evaluate and treat transgender patients in a manner that respects their unique transgender, medical, mental health, and psychological needs. Another is violence and harassment. Research consistently shows that incarcerated trans and gender diverse individuals experience disproportionately high rates of physical, verbal, and sexual abuse, both from staff and fellow detainees. Without staff training on gender identity issues and policies which protect against inappropriate treatment, unfortunately, we see high rates of abuse against this population. The United Nations Office on Drug and Crime reports that transgender people in prison are estimated to be up to 13 times more likely to be sexually assaulted than cisgender people. That is why this is necessary. These challenges underscore the urgent need for legislative intervention to establish policies and protections that safeguard the dignity, health, and fundamental rights of trans and gender diverse individuals in Nevada's jails. In addition to addressing the crisis that is the treatment of trans and gender diverse people in custody, SB 141 could be considered wise for the state of Nevada if we remember a recent case where Jenna Faith, a trans woman, filed a lawsuit against Steuben County, New York, alleging harassment and discrimination during her pretrial detention, which led to a settlement that resulted in one of the strongest jail policies in the country, protecting the rights of transgender, gender nonconforming, non-binary, and intersex people in custody, as well as a $60,000 payout to Jenna Faith. This is but one example of the recourse that incarcerated trans people have found since the 1994 Supreme Court decision Farmer v. Brennan, which provides precedent for trans people to argue that the failure to protect them from sexual abuse and other violence and failure to provide transition-related health care is cruel and unusual punishment in violation of the 8th Amendment of the U.S. Constitution. SB 141 not only protects gender diverse Nevadans who find themselves in jail, but it protects corrections staff from having to navigate the care of this population without proper guidance. And it protects the facilities and counties from potential legal problems based on the mistreatment of incarcerated people. People deserve dignity, respect, and protection and continuity of their health care, even if they're in jail. SB 141 helps guide everyone to protect that dignity, respect, and protection to a population they may need some help navigating the care of. Thank you.
That concludes our presentation, and we would be happy to take questions from members of the committee.
Members, any questions? We'll start off with Senator Krasner.
Thank you, Vice Chair. Thank you for your presentation. So I just wanted to clarify a couple of things. You said law enforcement is working with you on this? Great. And then the other thing, some of these changes, these are just factors that will be considered, correct? Not mandatory. Is that right?
That's correct.
Okay, great. And then one more, Vice Chair, if I may. I'm just looking down at nothing in this section shall be construed to require counties, cities, town jails, or any detention facilities to build new buildings, create new facilities, implement any additional staff training or programs. Is that correct?
Yes, that's correct.
Thank you.
Next, we'll go to Senator Hansen.
Thanks, Mr. Vice Chair. No, I got a ton of questions. I mean, look, there's a reality factor here, especially since I represent a bunch of small rural areas. The costs, it's an unfunded mandate. Essentially, I just don't see how it's possible to do all these things in a smaller area unless you flat out segregate people that are any of these titles completely away from the rest of the prisoners. And then there's the question, number one, how do you, because they don't have 24/7 supervision constantly, how do you deal with the liability factor? Okay, you have a transgender male that's put into the, I'm not sure, I don't know of all the exact terminology. So a biological male that's put into a female housed units because that's how he identifies, and then he rapes a woman in there. Who's liable in that situation? And then you have a woman, like you mentioned, menstruating, but she's in the male portion of the prison or jail. How do you prevent her from being raped short of flat out isolation and segregation of her?
So, Melanie Scheibel for the record. And I do appreciate these questions. I'm not sure why this was tagged as an unfunded mandate to begin with, and so I hope that we've been able to address that with the amendments. It's not my intention to put mandates on these jurisdictions, especially not the smaller jurisdictions. That's why it's intended to be a policy. To your first question, I would hope that all jails and detention centers do have 24/7 surveillance or supervision. I hope we don't have jails where they're leaving people overnight without supervision. But if we do, I'd be very interested in following up on that. And I want to make sure that I'm being clear about the subsections, particularly subsection C about housing, indicates that the person's preference is a part of the decision-making factors. It is just one piece. And so really this is more about treating people with dignity and respect than anything else, because absolutely it is the responsibility of the person who runs a jail or a detention center to ensure the safety of every person who is incarcerated. And we recognize that there are not good solutions in many cases. Sometimes there are no good solutions. And to your point, many trans and non-binary people are in fact housed in what most facilities called administrative segregation. They are housed by themselves. And I'm not here to say that that necessarily is wrong or bad, or that we need to move people out of those segregated facilities back into the general population. The purpose of the policy is to ensure that people are being treated with dignity and respect as those decisions are being made. To ensure that when somebody comes into the facility who is transgender, they're not automatically placed in administrative segregation and then never seen or heard from again. The purpose is to ensure that somebody has a conversation with that individual, learns a little bit more about who they are personally. They ask them where they would like to be housed, and they don't necessarily follow that preference, but that should be giving the facility some information and some guidance. And the answer may be no, you can't be housed where it is that you are requesting to be housed, but we want to ensure that those decisions are being made on a case-by-case basis, because maybe, even in these smaller facilities, maybe somebody wants to be housed in the men's section of the facility, and there are no other men incarcerated at that time. So maybe they can be housed in the men's facility on that particular day. And, I say that a little bit tongue-in-cheek, but not entirely, because we do have jails that have only 3, 4, 5 cells here in the state of Nevada. And so the purpose is to ensure that as these decisions are being made, they're not being made out of haste. They're not being made out of a misunderstanding of what it means to be trans or to be gender non-binary, but they're being made thoughtfully with just that little bit of extra time and attention paid to an individual person, to go through the factors and say, well, we're concerned about your safety, we're concerned about the safety of others, we're concerned about your preference, and any other factors they might have, crowding, availability of staff, maybe part of the jail is flooded right now. All of those should be factors in determining somebody's housing. And so ensuring that preference is one of those factors ensures that we are treating people with dignity and respect, even when they're incarcerated.
Well, I'm fine with the dignity and respect point, but your testimony was they're 13 times more likely to have vicious things done to them. Okay, and so even now we're not talking a 24-hour stay, we're talking incarceration in a jail, which can be up to 364 days. So, and the reality is we have rapes and brutal beatings and everything else currently, even with the oversight that we tried to provide. And if these people are extra vulnerable, then the only way I see to really, truly, minimize the damage is to basically figure out a way to house them completely separately or something like that. Anyway, no, I'm fine with the dignity. I don't want anybody to be more humiliated than the process of being incarcerated and going to jail for breaking the law is. But on the other hand, there's just a lot of really pragmatic aspects of this that I'm like, okay, how in the heck is a jailer or the sheriff or whatever in Humboldt County, Nevada, supposed to deal with all these things, or Esmeralda County or Mineral County or all the smaller ones, like you say. I have jails where there may be 5 to 10 cells total for everybody in the whole facility. So dignity I'm fine with. It seems to me like we're setting ourselves up for huge liability issues. If you have, like, frankly, if I was a male and wasn't like I am, and I'm going to spend 364 days in jail, I want to be in the female section for obvious reasons. So how do you go, the jails get to determine, well, look, I think I'm transgender or whatever the terminology is, and I want to be housed in the female prison. And while I'm in there, if I have an opportunity to have my way with a female inmate, that's my ideal. So I'm just kind of wondering how so much of this is so subjective that I just feel really uncomfortable allowing the sheriffs or the DA or whatever to make these calls and then have the liability for a rape or something even worse then falling on the county commission, their policies, whatever the financial insurances they have and so forth to cover things like this.
So Melanie Scheibel, again, Senate District 9. I do see the concerns that you're raising, and I think that, as an attorney, I'm always concerned about liability, and I would hope that this would actually help jails and detention centers to avoid liability by requiring them to develop these policies before they encounter an issue. Because if they can say that, back in 2025, we determined that, part of our policy is we're going to, take into account the preference of the incarcerated person, and they could include in their policy, we will, we will ensure the safety of, the entire population. Then when down the road there is a complaint, which hopefully is not of the nature of I was sexually assaulted, but is of the nature of I was segregated when I wanted to be in the general population, the county or the city will be able to point to their policy that says our policy has always been that safety is a factor and preference is taken into account, but it's not a deciding factor. And so then they would be able to, address what I think are actually probably the more common lawsuits, which come from people who are trans and non-binary, who are suing local counties and jails and detention centers because they are not being treated fairly and they're not receiving, any kind of consideration for their preferences in housing, in medical care, in, the gender of the officers who are conducting searches. And so I think we need to balance both of those possible liabilities. And it's a kind of a basic tenet of the law. Having a policy in place protects you as the defendant party. If you have a policy that you can point to, you're in a much better position to say, hey, whatever happened, but we followed our policy, as opposed to waiting until something happens and saying, oh man, at the time it seemed like it was a good idea to house this person in this location, but we don't have any rhyme or reason for why we did that.
But in Section 1, the strikeout, you're striking out the actual policies that they should have in place right as we speak. Look at Section 1A, red strikeout. Apply the generally accepted standards of care and best practices for all of the things you're talking about now. Are you saying that the policies right now are insufficient?
Melanie Scheibel, for the record, the opposite, actually. I got feedback from law enforcement that subsection A was too broad, and especially that there was concern about the medical and mental health treatment of incarcerated people, and so that's why instead I kept the ones that law enforcement agreed they could meet, which, as we read the language, includes housing. I guess that's the only one that's in subsection A, but the current policies include housing, searches, clothing, medical care, and grievances. And so I broke those out instead to meet that, I don't know if question is the right word, after conversations with law enforcement.
All right. Well, thank you, Madam Chair. Thank you, Mr. Vice Chair. So, yeah, I still have lots of questions. So if the opportunity comes to ask the law enforcement folks when they come up in favor of it, I'll ask them too. Thank you.
Members, any additional questions? Seeing none, Madam Chair, I'd like to invite you back to sit back in the gallery, and at this time I'd like to invite those wishing to testify in support of Senate Bill 141 to please come forward. Carson City or Las Vegas. Seeing no one in Las Vegas, we will start with the folk here in Carson City. Good afternoon, welcome, whenever you're ready.
Good afternoon. Thank you for this opportunity. My name is Brooke Maylath. That's BROOKE MAYLATH. This bill started out with a conversation that I had with Chair Scheibel about the possibility of lawsuits against our county jails, and if they were to incarcerate a trans person, what would the liability be, similar to Steuben County? The important part to understand about the liability is the liability works two ways. There's, a danger of how you've incarcerated somebody, how you've housed them, etc. But there's also the liability about violating their civil rights, which is what led to the mistreatments and the violations in the court settlement in Steuben County. We're trying to be able to make the language of this broad enough and working with law enforcement to make this guidance as opposed to a strict one-size-fits-all, so that we can work and find a way to be able to use gender identity and self-identity as a way to include in the risk assessment. So when you talk about somebody being placed in the along with women, that may be a trans woman that may not have had surgery yet, so still has a penis. What is that risk? If they're in for drunk driving and not for sexual assault, and there's no record of sexual assault, the risk might be very, very low. So it's all about that interview process, which is the part that each county, sharing information with other counties, can be able to share the wisdom of what works, what doesn't work, to be able to mitigate risks all around, because we need to be able to protect the safety of staff, the safety of other inmates, the safety of just the general population, and only the staff that is present during that interview process can understand who are the populations that we have, who is safe for placement for whom, and that we have to be able to trust with the wisdom of the people that have the guidance of a policy and a procedure to be able to make that appropriate evaluation for where you're putting that individual. So this just gives extra tools for the staff to be able to make an appropriate decision. So I urge you to be able to support this bill so that we can support our law enforcement in doing things that are going to be positive for them as well as for the people that they have to have in their custody. Thank you.
And thank you for joining us. Good afternoon. Welcome.
Good afternoon, Vice Chair Flores and members of the committee. My name is Kayla Maese, spelled Kaylah. Last name is Maese. I'm a civil rights analyst at the ACLU of Nevada. We thank Senator Scheibel and Silver State Equality for working on this piece of legislation. We do believe it's very important, and the ACLU of Nevada supports SB 141. Thank you very much.
And thank you for joining us. Good afternoon. Welcome.
Good afternoon, Vice Chair Flores, Senate Committee on Judiciary. My name is Chris Reese. It's R-I-E-S. I represent the Las Vegas Metropolitan Police Department. I want to first start by saying that we currently provide a safe, secure, and humane environment for all inmates. Transgender inmates are no exception. There are still conversations to be had with Senator Scheibel, but we are in support of SB 141 and the policy of this legislation, which is in essence continuing what we currently do at CCDC, which I would like to mention is accredited by the American Correctional Association and the National Commission on Correctional Healthcare. Thank you.
Thank you for joining us. Good afternoon. Welcome.
Good afternoon. Angela Knott from the Washoe County Public Defender's Office, ANGELA-KNOTT. Just wanted to briefly share with you guys a story of a client we had recently. They were housed at the Washoe County Sheriff's Office for a little over a year while they were pending trial. And there were some issues that were raised that we were made aware of. And one of the concerns was the medication that this person had to take. She was taking the HRT medicine, which is the hormone replacement therapy medication. And because I think there was a lack of policies and it's not a common individual to have in the facilities, there were a lot of inconsistency in how she was getting the medication. And the problem with that is not like just, getting like a razor to shave your face for court. The problem is this can lead to actual medical issues, including stroke and other heart-related concerns. So that was just one issue that was raised, that she was suffering from lack of medication. The second one was the housing, and what happened was they didn't know quite where to put her, and she was placed in a men's unit. It was a special unit, and that's the unit that was mainly for sex offenders. So she was not there on a sex offense crime, but that's where they had placed her. And besides just being kind of segregated and humiliated, it's also a lot more restrictive of a unit. So there's, like you don't really get to go and have a job in the jail. So there's just a lot of restrictions that were placed on her just simply for being her. The criminal process is very stressful as is. And so when you're just placing that extra layer or that extra level, it's not only really confusing for them, but also for the staff, right? The jail staff, without proper policies or procedures, don't quite know where to go and what to do and how to maybe better address these certain inmates. I know that the Washoe County Sheriff's Office is making significant improvements over the years, and I know that they want to continue to improve on their policies and procedures. So we just believe that SB 141 is really important, and because consistency is important. So we're asking you to support this bill. Thank you.
And thank you for joining us. Good afternoon and welcome.
There you go. Thank you, Vice Chair, members of the committee, Harrison Epstein, legal extern, Clark County Public Defender's Office, HARRISON, EPSTEIN. Quite simply, this bill is a step forward in protecting the rights and dignity of incarcerated transgender and non-binary people, creating policies that acknowledge, respect, and affirm the gender identities of incarcerated people will benefit their mental and physical health, as you heard in today's hearing. This bill will lead to better rehabilitative outcomes for transgender people in prisons and jails, and we commend the work of these prisons and jails to take these steps as they come. Thank you.
And
Good
thank you for
afternoon,
joining
Vice
us.
Chair Flores, members of the committee, Jason Walker, JASON, representing the Washoe County Sheriff's Office, supporting Senate Bill 141 as amended. And again, like Detective Reese said, it is the policy also of the Washoe County Sheriff's Office to receive, evaluate, house, and provide safe and humane custody of all persons. We're very appreciative of Senator Scheibel's willingness to work with stakeholders involved and look forward to continued discussions on this bill. And just from the Washoe County Sheriff's Office standpoint, we have 4 criteria when it comes to determining proper housing. They are a statement of preference form that we get filled out in the intake process, the anatomical gender of the inmate, the individual's adjustment to incarceration, as well as other psychological factors that may contribute to either the individual's resiliency or vulnerability. And speaking to Senator Hansen's point, oftentimes we are stuck in a place where we have to house this person in what we call administrative status, where it's not necessarily a female general population unit or a male general population unit. Just unfortunately, they just fall in that administrative status. Obviously, open to further communications on this topic, but supporting Senate Bill 141.
And we do have a follow-up, please. Senator Hansen.
Thank you, Mr. Walker. A couple things. The public defender for Washoe County just mentioned a specific case in which an individual that falls into these categories was placed in the sexual offender category. I assume that was done not to punish them, but because of the heightened level of security, basically. More restrictive, so less likely that physical injuries could occur. Is that how you deal with that in the Washoe County jails when you have this type of a situation?
Jason Walker for the record. Thank you for the question, Senator. And yes, that administrative status, oftentimes sexual offenders happen to fall into that unit because based off of vulnerabilities, resiliency, nature of charges, they're unable to be placed in general population. People find out somebody's charges and they want, we do have 24/7 coverage, and we make sure that the inmates that are in our custody are as safe as we can attempt to get them to be, but oftentimes fights do break out. A lot of incarcerated persons generally tend towards to end up in the administrative status. That way we can put a little bit more protection on them. They don't get out for what we call tier time with large groups of people. Oftentimes we break them up into smaller segments and allows us to give them a little bit extra security because of that.
Okay, well, no, that was one of the concerns, though. Basically, you segregate them out and isolate them because for their own protection, you have to. So, it seems reasonable to me, but on the other hand, you're kind of getting chewed out for maybe singling them out. Now, the question of medication came up. This individual, according to public defenders, was 364 days, so gross misdemeanor or something like that. What is the policy of Washoe County Sheriffs as far as medication?
We have a vigorous health and welfare programs established by NAFCARE. I can't speak to this individual incident where somebody was alleged to not get their medication. I do know that upon intake, we start to determine somebody's medical needs as soon as they come into custody, along with regular follow-up. I don't have any previous knowledge of that, and I can't speak to that, but I could tell you that we have a robust health and welfare NAFCARE system that's in there that takes into account every inmate that's in our care and custody.
And one last question for you. How many inmates do you guys normally process through the Washoe County Sheriff, Park Boulevard facility in a year?
Jason Walker, great question, Senator. Generally, our bookings and releases are about the same. I would say anywhere from 40 to 60 daily.
Daily. Now, and what percentage are transgender in a year? Do you have any idea?
Jason Walker, less than 10% would be my best guess.
That high then, 4 out of 6 every day that come through the jail?
That'd be my best guess, yeah. Generally, we have between 1,000 and 1,100 inmates, so there might be 50 to 100 that fall into that category. And again, our administrative status housing unit, I don't know the number of persons that can be in there, but generally we have 112 inmates per housing unit. That administrative status, some of them are single bunks, some of them are double bunks, but I would say less than 10%.
Okay, thank you. Mr. Vice Chair, one thing I do want to point out, I don't see him, maybe they're here, that would be the Sheriffs and Chiefs Association lobbyist. I don't see him here, and that would be the one that would cover my rural constituencies especially, so just want to hopefully hear from those folks because there are some significant costs, in my opinion, for some of this kind of stuff. I'm sorry, Jason.
Vice Chair, if I could jump in on that. I was in communication with Lieutenant Woodard today. He is, at this point, good with supporting Senate Bill 141 as amended. We are working on some language, and again, he shares your concerns. Selfishly for me, I'm in Washoe County, and Clark County is a little bit different. Some of the smaller counties just don't have the access to the continuing care and custody and some of those other things. They might have a total of 10 jail cells where we have 16 and 17 housing units. So Lieutenant Woodard is in communication with me. He's good with where we are in this point. Obviously, continued conversations, he'll reach out to some of the smaller counties.
Thank you, yeah. Mr. Vice Chair, one thing I would point out is while they don't have the facilities, they do have the potential liability, and they don't have the kind of deep pockets that Clark and Washoe would, frankly. But anyway, thank you, Mr. Vice Chair.
Thank you. Please continue.
Thank you, Vice Chair, members of the committee. For the record, Serena Evans, S-E-R-E-N-A, E-V-A-N-S, and I'm the Policy Director for the Nevada Coalition to End Domestic and Sexual Violence. SB 141 is an important bill in protecting vulnerable individuals and preventing violence. Trans and non-binary individuals experience rates of interpersonal violence at increased rates and are often targeted for sexual assaults within our jail and prison systems. A jail sentence should not be a sentence for sexual assault and violence. And I also want to note that a person seeking to abuse the system and claim that they are trans so that they can then be housed within the women's jail to sexually assault them is a predator, plain and simple. We appreciate wanting to keep all individuals safe, but that individual claiming to be trans to assault others is a predator and a violent individual. Trans individuals who are incarcerated are statistically much more likely to be victims of sexual assault themselves, and they are deserving of safety, dignity, and respect. And so we support this bill. Thank you.
Thank you. Good afternoon. Welcome.
Thank you, Vice Chair and committee members. My name is Nick Shepak, N-I-C-K-S-H-E-P-A-C-K. State Director of the Fines and Fees Justice Center. Simply, with this piece of legislation, we have found through many years of work that written policies are extremely important. What this bill seeks to do is have each jail write policies that work for their jail. When we do not have written policies, we lead to lawsuits, which increases the cost to the county, and often that cost is passed back on to incarcerated individuals. What those policies look like is not as much of a concern as our organization, but any time that we are requiring written policies from our incarceration systems, we feel that benefits everyone. Thank you.
And thank you for joining us. Anybody else wishing to testify in support? Seeing none, BPS, do we have anybody wishing to join us over the phone in support of Senate Bill 141?
If you would like to testify in support of Senate Bill 141, please press star 9 now to take your place in the queue.
Good afternoon, Vice Chair Flores and committee members. In support of SB 141, my name is Bree Schmidt, BRISCHMIDT, and I am a program associate with Silver State Equality, Nevada's statewide LGBTQ+ civil rights organization. We seek to bring the voices of the LGBTQ+ people and allies to institutions of power in Nevada and across the United States. Thank you to Senator Scheibel for sponsoring this bill. Transgender Nevadans already struggle to access healthcare, housing, and employment. Without consistent standards of care in place, transgender individuals kept in a local detention facility may continue to face challenges by being denied gender-affirming healthcare, proper housing, and necessary protections from being a victim of violence and harassment. Codifying these standards outlined in SB 141 will help to improve the detention system in Nevada for transgender persons, the staff, and the detention facility officials who are responsible for their treatment under the law. We urge you to support SB 141. Thank you.
Thank you for joining us. Next caller in support of Senate Bill 141, please.
Good afternoon, committee chair and members. My name is Luisa Benasano. For the record, Luiza Benisano. I am the Campaigns and Community Engagement Manager for Planned Parenthood Votes Nevada, and we strongly support SB 141. Thank you.
Thank you for joining us. Next caller in support.
If you're just now joining us and you would like to testify in support to Senate Bill 141, please press star 9 now to take your place in the queue. Chair, the public line is open and working. However, there are no more callers wishing to testify in support at this time.
Thank you. At this time, I'd like to invite those wishing to testify in opposition to Senate Bill 141 to please come forward, Carson City or Las Vegas. Seeing none in Las Vegas, we'll start here in Carson City. Good afternoon, welcome. And sir, I believe your microphone may be off.
Thank you. Good afternoon, Vice Chair and Committee. My name is Joshua Skaggs, and I'm the Legislative Affairs Director for the Nevada Republican Party, here today in opposition to SB 141. SB 141 is an extension of Senate Bill 153 from 2023, adding county and local facilities to the unconscionable mandates placed on state prisons last session. SB 141 is an attempt to deny reality because science doesn't allow you to actually change your gender no matter what surgery you have. Regardless, individuals can usually identify and present as whatever gender they choose without a problem. But there are places, such as the military, sports, and prisons, where doing so may infringe on others' rights to privacy, and in some cases are actually dangerous. This bill puts staff in danger and also endangers and infringes on the rights to privacy of gender-conforming prisoners in danger and opens up the state of Nevada for litigation risk on a number of fronts. First, in states where gender nonconforming inmates have been housed with inmates of the same gender identification, sexual assaults and harassment are rampant. Consider the gender nonconforming inmate at Rikers Island in New York who received 7 years for raping a female inmate while he was housed in the women's jail. Or the example in California, which allows male sex offenders to transfer to women's prisons with predictable outcomes, including HIV outbreaks due to sexual assaults. Why is there more concern about how an inmate chooses to identify than about the officer who puts their life on the line every day to keep dangerous felons off Nevada streets? Non-conforming felons can easily protect themselves in prison simply by identifying as their actual biological gender while incarcerated without endangering the majority of the other prisoners and staffs. We strongly urge this committee to protect the vast majority of felons, correctional officers, and Nevada citizens and oppose this dangerous bill. Thank you.
Thank you for joining us.
Sorry about that. Good afternoon, members. My name is James Gansinger, JAMES-GANSINGER, on behalf of the Republican Party of Nevada. This bill shows more concern for the rights and privacy of non-conforming gender prisoners than the rights and safety of law enforcement personnel and the rights and safety of gender-conforming prisoners, including their right to privacy. Our prisons have serious problems already that are unresolved. For example, the escaped Luxor bomber who was on the run 4 days before the state even noticed that he was gone. Perhaps instead of focusing on pronouns, our prison system should be focused on keeping convicted felons incorporated. Rather than focusing on cultural competency training, as described in Section 1, let's focus on keeping dangerous criminals locked up. We already have a shortage of guards and difficulty recruiting. How much harder will it be to recruit and train qualified correctional officers when they have to worry about a prisoner suddenly deciding to change their pronouns? We've heard from officers from Washoe County and Clark County, large urban environments. What about the rural counties? What about the small towns of Nevada? How do they comply with this legislation? Gender identity is a moving target. If you go to Wikipedia and look at the different genders that exist today, you'll find one called fluid gender. A person with fluid gender is one whose gender changes based upon the mental process of the person. So a man can be a man for dinner, but then his gender identity changes when it's time to go to bed, and now he's a woman. How do you deal with that identity problem when you're a deputy in Story County? Once you impose these new statutory duties, and do not kid yourself, whether you say these are mandatory or simply things that are to be considered, you're imposing statutory duties on counties, towns, and correctional personnel. Once you do this, how many lawsuits will be filed by deep pocket, so-called nonpartisan 501c3s against hardworking correctional officers who misgender a prisoner or otherwise allegedly do not comply with these new legal obligations? Because you are imposing new legal obligations. We had the witness from the Public Defender's Office who was talking about her client, a prisoner who was apparently mistreated. Impose the statutory duty, she has a new cause of action. This is not good law. Thank you.
Thank you for joining us. Anybody else wishing to testify in opposition to Senate Bill 141? Seeing none, BPS, do we have anybody wishing to join us over the phone in opposition to Senate Bill 141?
If you would like to testify in opposition to Senate Bill 141, please press star 9 now to take your place in the queue.
Good afternoon. This is Bruce Parks, Bruceparks. I find it amusing that we don't refer to this as it actually is. We use all the colorful euphemisms that have come out over the course of time, and we refuse to acknowledge calling these ailments what they are, according to DSM-6, gender dysphoria. That is actually what the problem is. Now, I would caution anybody that supports this bill that the cost of law enforcement agencies is not included in this bill. And there is a cost associated with this. Not to mention the cost of taxpayers when law enforcement actually tries to get a person with gender dysphoria the appropriate help they need instead of enabling their delusion, and that person sues the county. This is a poorly thought out bill, and it is bad for the Nevada taxpayers. Vote no on this bill. Thank you.
Thank you for joining us. Next caller in opposition to Senate Bill 141.
Hi, this is Katree Saunders, for the record, Katree, last name Saunders, and I oppose Senate Bill 141. I believe that women should be able to be protected. All people should be protected, but there should not be a loophole for people who want to harm people unnecessarily and have gender dysphoria. Thank you so much for your time.
Thank you. Next caller in opposition to Senate Bill 141.
Good afternoon, members of the committee. My name is Christiane Mersch, Christianemersch. I'm a concerned citizen and taxpayer in Nevada. We are so opposed. Also, I'm a Latina immigrant here. I found a chapter, Moms for Liberty. A lot of families are opposing this bill. We care about a woman. It's sad that just only one senator was asking the right questions in this hearing. Only Ira Hansen is concerned about women. Only him is concerned the overload and pressuring our law enforcement. Only him is concerned about the liability. And we are concerned also about taxpayer, like we're going to have a cost this. And we ask to oppose this because male prisoners who claim to be women, they're not vulnerable. In fact, they're more dangerous than other men. There's a persistent narrative among trans activists that the trans-identified male prisoners are incredibly vulnerable, but they're not. In fact, they have no choice but to take shelter among women. And this is sad. It's sad that this bill already was passed and you are having all this amendment. I think this whole bill should be repealed. We have more vulnerable people in our prisons. We have like elderly men, young men, and women. They're the vulnerable ones. So we should take a look also that President Trump did an executive order banning all this insanity, gender ideology, extremism that is across the nation. That's why he was elected here in Nevada, because of his agenda. So just take a look on that, because a lot of people, a lot of immigrants, a lot of Latinos like me, they don't want this here. We care about law enforcement, we care about the rule of law, we care about our women being safe. So please vote no on this bill. Thank you.
Thank you. Next caller in opposition to Senate Bill 141.
Hi, Yolanda Canuck. Yolanda, last name Knaak. The most important thing that I have a problem with is putting trans people in with female inmates. I see that there could be some serious problems there for our female inmates. So I'm totally opposed to that. The second thing that has been brought up already, so I just make this really quick. There's a lot of sheriff substations, like there's one where I live, and they would not have the ability to put somebody that's trans in by themselves, possibly, and so that could be an issue. And then thirdly, when you start providing rights for prisoners of any kind, the problem you run into is that you're opening the door to lawsuits against the state of Nevada. And so anyway, I'm opposed to this bill. Please vote no. Thank you.
Thank you. Next caller in opposition, please.
Hi, my name is Grace Trujillo. I would like to state my opinion and I oppose SB 141. I wanted to ask the committee, do they oppose the elected majority of our county, our Nevada, on President Trump? They opposed what he said, the executive order, there's only two gender. I would like that to be put in question for what they are putting into this bill. Or are they think that they are above our president? SB 141 raises serious concerns about its potential negative impact on the residents and public safety. If enacted, unknown funding threatens to strain local government's budget, forcing them to divert crucial resources away from essential services like police patrols, emergency response, and community programs. This reallocation could severely diminish the protection and support that residents rely on. Moreover, the inconsistent implementation of mandated policies and optional training across different jurisdictions could create significant disparities in the management of transgender, gender and non-conforming, and gender non-binary and intersex prisoners. Such inconsistency may lead to confusion and inadequate oversight in detention facilities, increasing the likelihood of security breaches and mistreatment. These not only jeopardize the safety of inmates, but also endangers the staff working in this environment. The diversion of funds to accommodate these new requirements could undermine overall public safety infrastructure, leaving local communities more vulnerable to crime and ill-equipped to respond effectively to emergencies. Thus, this bill's implication could compromise individuals' well-being and the safety of our neighborhoods. Please stand for the president we voted for and do not force policies based on ideologies and emotions. Please put bills that are fair for everyone, Nevadians. Speak and represent us because we voted for this, which is two genders only, to be recognized in our state. Thank you.
Thank you. Next caller in support of, opposition to Senate Bill 141.
Good afternoon. This is Tammy Romo, Tamiromo. I want to state that every caller that spoke before me, all of them had good arguments, but the basic one for me is that there's only two genders, and if we bend for the genders, what else are we going to bend for? If we start segregating and having them choose where they want to go in a punishment facility, others can sue as well for not giving into their demands and needs, what they see fit as well. But mostly all the arguments before me, there's only two genders. We have to support our president and the executive order and not open Pandora's box to many other problems that can transpire if this bill is passed. So I oppose SB 141. Thank you very much.
Thank you. Next caller in opposition, please.
Hi, this is Katrina Ivanov, aka Mrs. Fixit. I'm longtime resident of Clark County, Nevada, and I'm very disappointed at how you guys are taking care of our taxpayers' money. We pay a lot of taxes, and yet it feels like we can. You don't listen to us how those money want to be spent. That bill is a lose-lose situation for the taxpayers. Transgenders are going to be suing because their wish list of being one gender today, another gender tomorrow, cannot be fulfilled at all times. And women, for sure, I hope, are going to be suing. If you keep passing bills like that, I hope women would be suing when they get raped in those jails, because you are not sending women to them. You are sending men. That's why we have two different jails for men and for women. That's why we keep things separate. That's why we have different bathrooms. That's why we have Title IX. You are breaking the women's constitutional rights protected under Title IX. It is very disappointing that we have enough problems as it is with economy, with education, with many other things. And instead of you doing something to fix the problem, you're creating more problems with such poorly written bills that are against every logic and everything we've been learning within the last however many years humanity exists. I feel bad for transgender people. Don't get me wrong. I feel for them. They are sick. They need help. But this bill is not going to help them. This bill only is going to put them in worse position, and most importantly, it's going to put vulnerable women in a very, very bad situation. Please vote no to that bill. And I understand that you guys are not very happy with the election results. However, we were very loud and clear. We don't want this nonsense to continue. So please start listening. If you go on Nellis, 70% of people are in opposition. I'm pretty sure this is not only Republicans. We're not as active as Democrats. So think about that. 70% opposition. Please vote no on that bill. Thank you.
Thank you for joining us. Next caller in opposition.
BYRUS, HOJJATY. Thank you so much for the sponsor and the chair for your efforts. And I just wanted to ditto the previous comments. I just have a couple points I wanted to make. Number one, do other species like birds and leopards, lions, do they have these kinds of issues? I'm just curious, because that's just how nature works. And number two, I'd like to see how this program has worked in other states like California and compare the results. So I'm quite concerned about it. But other than that, thank you so much.
Thank you. Next caller in opposition.
Hi, good afternoon. My name is Elishaba Delote, Delote. I am vetoing everyone who commented regarding the two gender. And also, I am opposing SB 141 because it jeopardizes women's safety, which should be the top priority in our prisons. By mandating transgender policies without robust safeguards, this bill increases the risk of vulnerability for female inmates, while also burdening taxpayers and neglecting fairness and security concerns in the correctional system. Earlier, someone mentioned in the who is for this bill saying about the statistics, it sounds like they're making up numbers, carelessly making statements that don't support their data, because national statistics under transequality.org there are less than 1% incarcerated currently nationwide. Are we talking about majority versus minority? Safety of all biological men versus biological women. Feelings versus reality. Comfort versus safety. Who's paying for this? The federal? Earlier, somebody says about by law, there are two genders. So no, they're not going to pay for this. The state, as a taxpayer, no. We have more big issues than this. For instance, kids' education. So please, listen to the people, for you were voted there, and I hope that you listen to your moral values before you even vote for this. Yes, oppose this bill. This is an easy bill to say no, because this is about only two genders, men and women. Thank you.
Thank you. Next caller in opposition.
Hello, my name is Lorena Biastotti. I'm a CCSD trustee speaking for myself, and I oppose SB 141. I know this is not supposed to be a partisan issue, but this is why they call Republicans a party of common sense. When a woman identifies as a man and is housed with men, can she corner another man and rape him? When a man identifies as a woman, can he overpower her, rape her, and violate her in the most grotesque way? It is unconscionable to do this to us women. Can you just imagine somehow ending up in an unfortunate situation of being detained, a mother of yours, a sister or daughter subjected to this risk of being assaulted and raped with nowhere to run? How would you sleep at night knowing that you facilitated the scenario for them? And I would like to know, where are the women there, sitting there in our legislature, listening on this, weighing in on it, having the ability to vote to either defend us, protect us, or put us in this situation? Who will stand up for us? When is it enough? I urge you to please vote your conscience, vote no on SB 141. Thank you.
Thank you. Next caller in opposition.
Thank you, Vice Chair. The public line is open and working. However, there are no further callers wishing to testify in opposition at this time. Thank you.
Thank you. At this time, we'll go to those wishing to testify in the neutral position for Senate Bill 141. Seeing none in Carson City or Las Vegas, BPS, do we have anybody in the neutral position?
If you would like to testify in neutral for Senate Bill 141, please press *9 now to take your place in the queue. Vice Chair, the public line is open and working. However, there are no callers wishing to testify in neutral at this time.
Thank you. Madam Chair, any closing remarks you may have?
Thank you, Vice Chair Flores, and thank you, committee, for hearing this bill. There are just three things that I wanted to clarify and put on the record now that we've heard the opposition to this bill. The first thing that I want to make crystal clear is that SB 141 does not dictate where a trans, non-binary, or gender non-conforming or intersex person will be housed. It does not dictate anybody's housing. The housing policy decisions of a detention center, facility, or jail are still up to that individual facility. This bill does not change that. So just in case anybody is still belaboring under the misapprehension that this would require jails to make specific decisions about where to house people. Let me say it one more time. SB 141 does not dictate where jails or detention centers would have to house any particular incarcerated person, be they trans, gender non-binary, intersex, or cisgender. It does not mandate particular housing choices. The second thing I want to address is the idea that this is going to open up facilities to lawsuits. I'm guessing that the people in opposition who think this will open us up to more lawsuits are not attorneys, because attorneys know that the door is always open. The question for the committee is, what do we want the door to open to? Do we want the door to open up to, we don't know, there is no policy, we're not sure, let the courts decide? Or do we want the door to open up to a path that says, here are the things that this jail was legally, statutorily required and obligated to do, and if you ask me, the things in here are pretty minimal. I would have loved to bring a bill that included all of the medical care I wish that transgender people received in custody. I would have loved to bring a bill to develop new jail facilities for everybody who's incarcerated that are, more humane and allow them more programming opportunities. I would have loved to bring a bill that required institutions to evaluate everybody's mental health and provide them with all kinds of treatment options and rehabilitation programs. But instead, what you have in front of you is a very reasoned, measured approach that was negotiated, not even negotiated, developed in partnership with law enforcement. Hand in hand, we came up with what are those guardrails that the detention centers can meet. What are the edges we can put on that path when we open lawsuits' door to say, we're going to require that everybody's treated with dignity and respect. We're going to require that a preference is expressed for housing and medical care and the gender of the person performing a search. We're going to have a policy in place that says simply transgender and gender nonconforming people in custody also have their medical needs met at the same rate as people who are cisgender. Those are achievable goals. And by putting them into statute, we actually narrow the field of available lawsuits for anybody who's incarcerated. And finally, I really want to bring this home with understanding what the policy is supposed to do, the kinds of abuses that it's supposed to prevent. Because in Nevada, we have had a long history of bipartisanship in passing bills that honor, respect, and recognize the transgender community. What we have universally condemned is discrimination, hatred, and bad behavior, especially amongst law enforcement. Nobody on this committee has ever stood up here or sat at this dais or taken the floor in our Senate chambers to defend bad law enforcement officers. Yet they will always exist, just like there will be bad attorneys, there will be bad elected officials, there will be bad doctors, you name it. What this policy will do is allow a recourse for those individuals who are few and far between. The people who manage to work in correctional institutions but don't treat people with dignity and respect. I'll give you a really quick example. Subsection D, subsection 2, prohibits unclothed searches for the purpose of observing an incarcerated person's genitalia. That should be something we can all agree on. There should be no reason that any incarcerated person, as they're walking from their cell to the bathroom, to the showers, can ever be stopped by a corrections officer who says, you know what, I'm new to this unit, I don't recognize you, I want to see what your genitalia looks like to be sure you're housed in the correct place. That is never acceptable. Yet, it has happened. I don't know of a case where it's happened here in Nevada. I'm grateful for that. But we do know of cases where that has happened in other states and in other jurisdictions. And that's the kind of bad behavior that we're trying to prevent by creating a policy in advance so that if, and hopefully it doesn't happen, but if one of those irresponsible law enforcement officers comes to Nevada and and participates in that kind of bad behavior, when we open the door to a lawsuit, when we open the door to disciplining that officer, firing that officer, we already have a policy in place that says that that's not how we treat incarcerated people in Nevada. It protects everybody. It ensures that all incarcerated people are treated with dignity and respect. And it gives the sheriffs, the managers, the directors of jails and county detention centers, those institutions, it gives them the tools to discipline people who do not treat everybody with dignity and respect. Not only, but especially as it relates to people who are trans, gender nonconforming, or gender non-binary, or intersex. And so for those reasons, I look forward to continuing to work with people who have questions or concerns about the bill, developing the language to make it as good as we can possibly make it, and passing SB 141.
Thank you, Madam Chair. And with that, we'll close out the hearing on Senate Bill 141, and we'll wait for our chair to make it back.
Thank you so much, Vice Chair Flores, for running such a smooth and informative bill hearing on that. We now have one item left on our agenda, which is public comment. If there's anybody here to give public comment in person, I'll invite you down to the front now. I don't see anybody in Carson or Las Vegas in person to give public comment, so we'll go to the phones, please, for public comment.
Thank you, Chair. If you would like to provide public comment, please press star 9 now to take your place in the queue.
CYRUS, HOJJATY. I'd like to compliment the chair on how he does his meeting. I really like his style, his fashion, and I appreciate his work. I hope it prevails, and I think it's also as good as his predecessor, former State Senator Mo Dennis. He's a cool guy, too. Thank you.
Chair, the public line is open and working. However, there are no further callers wishing to provide public comment.
All right, thank you so much. That does bring us to the conclusion of our meeting. We do have a meeting tomorrow. I think we finally got the agenda posted earlier today. We will be hearing a bill with a number that is 346 tomorrow. And until then, that will be same time, same place tomorrow. Until then, we are adjourned.